United States versus Crawford, number 124937.
May it please the Court, my name is John Bryson. I practice in High Point with Wyatt Early Harris Wheeler, and I'm representing the defendant, Donavon Crawford. This is an appeal from a conditional guilty plea from the Middle District of North Carolina. There are two issues on appeal. One, the denial of defendant's motion to suppress, where defendant challenged the affidavit supporting a search warrant for his residence. And also, the second issue is the court's determination that the defendant met the criteria for career offender. I intend to address the sentencing issue first. This issue concerns whether the defendant had the two requisite prior violent felonies for career offender. Factually, what happened was the defendant was arrested on one day and charged with a misdemeanor offense under North Carolina law, assault on a female. About 3 weeks, he's released on bond. About 3 weeks later, he's arrested again. This time he's charged with other offenses. The second time that he's arrested, there are charges that do qualify as violent felonies for career offender. He is indicted in April, a couple of months later, and when he's indicted, the prosecutor indicts him not only for the felonies that occurred in the second arrest, but they take the misdemeanor offense where he's arrested initially, and they elevate it to a felony charge under North Carolina law, assault inflicting serious bodily injury. The following year, he enters a guilty plea to both felonies out of the felony from the first arrest, which was elevated in the indictment process, and felonies from the second arrest. And the question becomes whether or not there is an intervening arrest. Essentially, what turns on whether or not these are counted separately or counted as one offense, because they were all entered as guilty pleas on one day, is the interpretation under the guideline 4A1.2 as to whether or not they're counted separately. And basically, it turns on whether or not there is an intervening arrest. The competing positions are, we contend that he's initially arrested for a misdemeanor offense, and so when he's arrested for the second offense, that's not the intervening arrest because you don't have a qualifying offense when he's initially arrested. When he's indicted for these offenses, that's when he's charged with a qualifying offense. But there's no intervening arrest because he was simply indicted under the same case file that he was originally charged with, so there's no intervening arrest between the first arrest for a qualifying offense and the second charge for a qualifying offense. There's no precedent in this circuit for this. We have emphasized the language of the guidelines itself, where it talks about being arrested for the first offense. I've also cited the Dean case, which is on page 20 and 21 in our brief. I would concede this is dicta. Mr. Barrett indicated that this was dicta. Truly, the Dean case is not factually on point, and I acknowledge that. At the same time, it was the only case I could find that was even close in this jurisdiction on the issue, and the language is at least supportive of my position. The government is citing and relying on, and the court below did rely on the Seventh Circuit decision of U.S. v. Coleman, which is cited on page 21 of our brief. In Coleman, you have a defendant who is in a similar situation. He was arrested for two possessory drug offenses, I believe in August and December of the same year. They were possessory offenses, so they would not have qualified as career offender for career offender predicate offenses. When he was indicted, subsequently, the prosecutor upgraded them to, I believe, possession with intent to distribute, which would be qualifying offenses under career offender. He also, like the defendant, pled guilty on the same day to both of those offenses. He made the same argument that I'm making here, and that is that there was no intervening arrest between qualifying offenses. And the Seventh Circuit rejected that argument and adopted a rule that was based primarily on looking at the conduct of the defendant rather than the charge of the offense. I distinguish Coleman in two regards. One is we don't really have enough facts to know. It just says he was charged initially with possessory offenses. We don't know if they were misdemeanor offenses or whether they were felony offenses. And I would just, I can't tell you whether that would have made a difference to the Seventh Circuit or not, but it clearly is something that's out there and causes me concern. The other thing I think that is distinguishing in Coleman is, in Coleman, I believe it was that Illinois was the jurisdiction, the charges were brought by law enforcement, whereas here in North Carolina, the charges are issued by a judicial official, a magistrate. And I would say that is a distinction.
Why is that a distinction with a difference?
Well, I think that when you have a neutral, detached magistrate looking at the facts of the case and making a decision of the case, I do think that gives more credence to the validity of what the initial charge is. And I want to talk about the distinction between.
But the initial charge was changed, so.
Yes, it was charged.
How does that strengthen?
Well, I think it goes to whether or not it's changed because of a change in the facts or a change in a decision as to how to prosecute the case. And let me.
You know, I'm just wondering though, Mr. Bryson, isn't the rationale behind application of these principles really that you don't load up on somebody who hasn't had a chance to straighten up and reform their conduct? In other words, if the two offenses occur without pretty much at the same time, or if there hasn't been a situation where you know, a defendant is given the benefit of the doubt, but when a defendant goes out and is arrested, commits a crime, then goes out and commits another crime and is arrested for that crime, you have a different situation, don't you, in terms of overall culpability? Isn't that kind of the rationale?
Yes, it is.
underlying this?
I don't disagree. Yes, that is. In fact, if you read the Coleman case, it talks about
Right.
someone who didn't mend their ways, and I don't disagree with that.
And we don't have a mend their ways situation here, do we, under the facts of this case?
No, he didn't. But I think what we're talking about is when to apply a very serious enhancement. Okay, and you want. I think when you're evaluating this prior conduct and whether it's worthy of this very serious enhancement, I think you have to look at several things. One is when the Coleman decision discounts the concept of notice. Okay, and I do think that notice is important. If we're going to look at his conduct and say he didn't mend his ways and therefore he's going to get this enhanced punishment, I do think it's important to look at not only what he did, what he knew and understood at the time. And this defendant walked out of the courthouse on January 20th, 2009, believing he was charged with a simple misdemeanor offense. And
That encouraged him to commit further crime.
no, but I think
In a way that wouldn't end if he'd been charged with a felony.
I do. If I if I'm driving home today and I get a speeding ticket on the way home, I might continue to speed again. Okay, but if I get a speeding ticket and I'm told by the officer, if you ever get another speeding ticket again, you will lose your license permanently for the rest of your life, I will probably be a lot more careful in my conduct. And I would suggest to you that's the argument that I would make in terms of notice. The other thing that I want to emphasize is in the Coleman decision, they're emphasizing the conduct, and I think it discounts the power of a prosecutor in just deciding what the charges will be. On pages 22 and 23 of my brief, I gave a couple examples in North Carolina law where identical conduct can be charged either as a felony or misdemeanor, and it's solely in the unfettered discretion of the prosecutor. Now you might say, well, that's not what we have here, and I would at least beg to argue that point, and if I may. North Carolina has different graded levels of assault. Okay, you have a simple assault, which is a class 2 misdemeanor. You then have higher levels of assault, and one here that we're dealing with is assault on a female. That's what we call a class A1 misdemeanor. It's higher than a level 2. You also have assault inflicting serious injury. That is not a felony. That is also a class A1 misdemeanor. Okay? And the government's brief, it points out that in this warrant it says, charges him with assault on a female, but it notes that she had a broken jaw. The victim had a broken jaw. And I want the court to know, it was not a mistake that the magistrate charged him with a misdemeanor and not a felony. Assault inflicting serious injury is a misdemeanor offense under North Carolina law. So the magistrate essentially had a choice, given these facts. He could have charged him with assault on a female. He could have charged him with assault inflicting serious injury. These are both A1 misdemeanors, but you don't get to a felony by having both of those elements. Now, what ultimately happened was he was charged with assault inflicting serious bodily injury. That is actually a relatively new statute in North Carolina. It was enacted in 1996. And serious bodily injury is defined as bodily injury that creates a substantial risk of death or that causes serious permanent disfigurement, coma, a permanent or protracted condition that causes extreme pain, or permanent or protracted loss or impairment of the function of any bodily member, organ, or that results in prolonged hospitalization. Now, if you look at the indictment in this case, it doesn't specify any of those underlying facts. So we don't really know whether any of those facts were actually present in the case. Or we certainly, and there's not enough information in the pre-sentence report to know whether those facts are present. But that charge was certainly brought based on that allegation. So I do question whether this is a situation where it was the defendant's conduct or a prosecutor's determination to, as you talked about, up the ante because he had come back as a repeat offender. I also, in talking about, in emphasizing the defendant's conduct in this case, I also think in an assault case where you don't have a deadly weapon, what a defendant actually does is not necessarily always, the resulting injury is not always predictive of what the behavior itself is. And I made reference in brief to what I learned in law school as the eggshell plaintiff, which I don't think I've actually discussed that since my first year in law school. But the idea is that you strike somebody in one way and some person suffers no injury. You strike another person in the exact same way and they suffer catastrophic injury. And so I do think concentrating on the conduct in this case is not something that we would like to see the court do. We think that you should look at what the charged offense is, follow the follow the guideline language, and you not follow the Coleman decision. I've got 2 minutes, and I can't really do justice to the argument on the.
You have preserved it. You don't lose it by not arguing it.
No, I understand that, but I wanted to briefly talk about the search warrant issue, and it's very factually based. But I've got 2 minutes. Let me go ahead and just say this about the search warrant. The search warrant, we contend, does not supply probable cause, and if you look at the search warrant, there's an introductory paragraph 5, where the officer makes all sorts of statements, and they're completely undated. We don't know when they happened. The main thrust, I think, of the search is this: they go on a specific day, August 9th, and at that time, we don't know whether they actually did a knock and talk and actually searched the residence, or whether they attempted to do a knock and talk and search the residence. But when they're leaving, they do a trash pull, and then they go and get a search warrant, come back the following day with a search warrant. And I think the best evidence for the government that there is probable cause to search here is from the trash pull. And my complaint with the trash pull is this: based on this search warrant, you don't know whether or not they had just searched the house the day before, because you don't know when this stuff occurred in the undated allegations from paragraph 5. And while ordinarily I would agree that a trash pull where they find paraphernalia and I think a small amount of cocaine would suggest that there's drugs in the house, if you just searched the house the day before and you didn't find anything, if there's evidence of a trash pull, that suggests that maybe he just cleaned up the day before rather than that there's still drugs there. I'll save the rest of my time for
Thank
rebuttal.
you very much.
Thank you.
Barrett?
May it please the court, I'm Cliff Barrett, representing the United States in this case. Your Honors, I would urge the court to adopt the holding in Coleman and the rationale in Coleman. Mr. Bryson's already summarized the facts of that case, but I think two of the important quotes from the case are that the defendant places too much weight on the arresting officer's original characterization of the offenses. And Mr. Bryson, I know during his argument, said one of the things that in his favor was that perhaps law enforcement brought the enhanced charges rather than the prosecutor's office. And I think that points out kind of the impracticality of that. The prosecutor ultimately decides whether to submit the matter to a grand jury for more serious charges, and I think for that reason that language in Coleman is important. The Coleman court also said once the defendant's been arrested, he's been arrested for all the charges that might be filed related to his conduct. For that reason, I would urge the court to follow Coleman. I think the facts in our case are very similar to the facts in that case. The notice issue that Mr. Bryson talked about, just a couple of responses to that. There's no notice required for any kind of criminal history calculation, and I would urge the court not to graft that requirement on to the criminal history section of the guidelines. The defendant in this case, the court is familiar with the facts of the two assaults. They're both fairly brutal assaults. The first assault occurred on January 13th, was charged on the 20th, but the argument is that the defendant could still mend his ways. He knows from the warrant, which is in the joint appendix, that he's broken the victim's jaw. He's released. He then has further contact with her approximately 3 weeks later, and on that occasion slams her to the ground. I think she has a bloody head and bloody mouth and has some loose teeth as a result of that. So nothing stops him from mending his ways as a result of the initial offense. The other thing that's a little bit lost in all of this is that for years this court held that assault on a female was a crime of violence. Before the change in structured sentencing, it was a very serious offense. And we had, I know the court has seen many defendants who have been held to the career offender guideline simply for assault on a female convictions. The other point Mr. Bryson raised was that the defendant is charged with a misdemeanor and then at some point his charge is converted to a felony. The defendant always has an opportunity to obviously defend himself against charges. In this particular case, the prosecutor, after meeting apparently with the officers, after reviewing the evidence, determined that it was a felony assault, not a misdemeanor assault, and charged it in that fashion. The grand jury returned bills of indictment. The defendant had an opportunity to defend himself and chose to plead guilty. So it's not some type of unfair surprise that he would plead guilty to this offense. The practical application of any other rule, Your Honors, I would suggest, would be difficult because it would force the court to basically find that it has to be offensive conviction in order, which is, I believe, what Mr. Bryson is asking the court to do, for an offense to count as a career offender predicate, as a crime of violence in this particular case. And that's extremely difficult in that the initial officers, for whatever reason, a variety of reasons, local officers don't charge the correct offense, don't charge a serious enough offense, don't charge an offense which a grand jury later determines is based upon the evidence. And for that reason, we would urge the court again to follow the Coleman case. Your Honors, as to the other issue, I would just say briefly, we would again urge the court to affirm the district court. District court had took significant time to review the search warrant and to make findings. And I would also say that the case is virtually identical to the Monteith case, which is a published case in this court in 2011. I think there's been one other published trash pull case, but that's the last trash pull published case which addresses these facts. And for that reason, the district court found probable cause and applied the good faith exception. We would urge this court to do the same.
Thank you very much.
Thank you.
Mr. Bryson, do you have any rebuttal?
If I may.
Sure.
I'd like to use my time just to talk about, since he did talk about the search warrant case, just to talk a little bit more about the search warrant.
In your discussion, could you address Monteith?
Yes, and I think, and I don't take issue with Monteith. Okay, I think that you have a factual distinction between this case and Monteith. I think that in an ordinary situation, you go out to somebody's house, you suspect they're involved in drugs, you do a trash pull, you find that there's drugs. I think that gives you I think that is probable cause for issuance of a search warrant. I don't have a problem with Monteith. What I have a problem with in this case is, as I read this search warrant, it says to me, and I noted in my brief, and it's in the court transcript, when we showed up to argue this, all three of us had a different reading of what this affidavit, what factually occurred as a result of the affidavit. And in our interpretation, what happened is they go to his house on August 9th, they do a knock and talk, they don't find anything. When they're leaving, they do a trash pull. Subsequent to that, they get this information from this Officer Massey from another sheriff's department, Person County Sheriff's Department. And on the basis of that information, what they get from Sergeant Massey and the trash pull, they then get a search warrant and go back the very next day. And my complaint with the trash pull is, because they just searched the house the prior day, finding paraphernalia, small amount of drugs in the trash that day, it doesn't tell them that there's drugs in the house. It very well much tells them that they cleaned up and got rid of everything before they got there. So I don't think a trash pull immediately following a search that was unsuccessful and didn't find anything doesn't yield probable cause to search again. That's the gist of what I want to say. And there's a factual question. We can all read this affidavit and come up with different things. Can I just make a few points about why I contend that there was only one knock and talk? And that is, it's referred to at some point in paragraph 5 as it says that the department conducted the knock and talk, not a knock and talk. It's referred to as the knock and talk. And also, the court interpreted there being a prior knock and talk, and then coming back on August 9th and doing an attempted knock and talk, and that he theorized that the defendant wasn't there, and there was a prior knock and talk, and there was an attempted knock and talk. One, I don't have a problem with that if it was the day before, as long as that prior knock and talk is in close proximity to the trash pull. I go back to my original position. I don't think that really gives you probable cause if the prior knock and talk is in very close proximity to the trash pull. And we don't know that because the information in paragraph 5 is completely undated. We have no idea, even if you accept the court's version. The reason I think there's only one knock and talk is on paragraph 7, it says the investigator determined, they ran his driver's license and determined that his residence was at 1023 Da Vinci Street. Well, in the prior paragraph says they did a knock and talk at his house and he was there. Clearly, they would not have had to run his history and find out where he lived if they'd previously done a knock and talk at his residence and he was there. So I think that the trash pull is not like it is in Monteith. Because they just searched the house and they didn't find anything. And I think the other information that's provided by the sergeant from the Person County Sheriff's Department is conclusory, and as a result, it doesn't supply probable cause. And so essentially you're left with the fact that he's on probation, and that there were bullet holes found on the outside of the house, which they acknowledge could be old. So we contend that there isn't probable cause. We also, because of the conclusory statements, contend that the good faith exception doesn't apply. And in the Wilhelm case, it cites a case from another jurisdiction that defines a bare bones affidavit as one that relies on wholly conclusory statements.
Thank you very much. We will go down and